This is Article 2, Section 204, Stay of Commencement of Action, Demand for Arbitration. A stay is a stop. A stay is a stop of the start of an action, right? The start of a case, right? Think of an action as movement. The start of a case is the movement of the case in the court system. Okay, so where the commencement of an action has been stayed by the court, stopped by the court. So the stop of the commencement of the action has been stopped by the court or by statutory prohibition. The duration of the stay is not a part of the time within which the action must be commenced. So think about it. If you're stopping something, you're stopping the case before it's even started. So that stop has no part of the case once the case is began. Part B, 204B, arbitration. Okay. Where it shall have been determined that a party is not obligated to submit a claim to arbitration. Let's just start here. Let's say a plaintiff wants to sue a defendant. The defendant says, no, I have this claim to arbitration. You can't just outright sue me. You need to file a claim to arbitrate before you even think of suing me. Okay, so let's go on with the next part. So where it shall have been determined that a party is not obligated to submit a claim to arbitration, the time which elapsed between the demand for arbitration and the final determination that there is no obligation to arbitrate is not part of the time within which an action upon such claim must be commenced. So, what this is saying, that there is no obligation to arbitrate. So the court has said to the plaintiff, no, you know what? You don't need to file a claim to arbitrate. You can just start your case and sue the defendant. And so the court is saying that. Now, within that time that it took for the court to make that final judgment and say, it's okay, plaintiff, you can just sue defendant. You don't have to file a claim to arbitrate. You don't have to do this one step and try to arbitrate before you sue him. You can outright sue him. The court has said you have no obligation to file an arbitration. So that time that it took for the court to decide whether or not the plaintiff had to file a claim to arbitrate is not part of the time within which an action upon such claim must be commenced. Okay, so let's say there's a certain time frame that the plaintiff has to start a case. That time that it took for the court to decide that the plaintiff is not obligated to arbitrate is not counted in it. Right? So then it says the time within which the action must be commenced shall not be extended by this provision beyond 1 year after such final determination. So what they're saying is that time it took for the judge to decide that you're not obligated, plaintiff, 1 year from that final judgment, you can commence the action, but not more than a year from the time of that final judgment that you didn't have to file a claim to arbitrate.